He has shaped the district attorney's office to reflect the values of the people that he serves and has built a 21st century district attorney's office of which we can all be very proud.
We have to seek justice, and we have to look at the charges, we have to look at the facts, the witnesses that we're going to have to prove the case, and then match those with the elements to determine whether or not we're going to be able to prove beyond a reasonable doubt. Every prosecutor must evaluate that and determine before they take a case to trial that they have the ability to do that. You know, the jury will make the ultimate finding and decision, and then the punishment is, of course, handed out by the judge.
What we look at is three things. Are there legal issues? Are there factual issues? Are there equitable issues? We rely on the system to educate us. When a case starts, and what people don't understand is they go, no matter what we do, when a case starts, it starts on nothing more than a police report. We don't get a police report and then call every witness, look at every piece of evidence. No, we look at a police report and we say, based on this report, do we believe there's sufficient evidence that we could get a verdict of guilty from 12 neutral, impartial members of this community who are committed to applying the law fairly and impartially and holding us to the burden of proving this person guilty beyond a reasonable doubt. Based on admissible evidence in light of all foreseeable defenses. So certainly sometimes we see cases, we go, wow, there are some issues here. And we may charge it anyway, because we think there are issues here, but it's the appropriate case to try. Plea bargains are an integral part of our system of government, of our system of justice. You know, we have 5 courtrooms here. There are 52 weeks in a year. That gives me a total of, maybe if I can try a case a week, a little bit more than 250 cases I can try a year. Well, there are about 10,000 of criminal offenses that we charge a year. So without plea bargains, guess what? 250 get tried and all the rest get dismissed. That's how simple it is.
I don't see any excess use of you know, a plea bargain. Sometimes a plea bargain is what I think I can prove and what the sentence is going to be, and then I have to make a decision. Well, you know, shall I burden the system, delay all those other cases, bring in jurors, you know, to hear a case where I think the conclusion will be a foregone result? You know, that doesn't make sense. And if I honestly do not think, you know, and know what's going to happen in terms of the sentence, one of the necessary tools we use is what is called the open plea. And what that is we look at the charges. We usually pick the most serious of the charges, and we tell the defendant, you plead to these charges open. And then what that means is the judge will make the decision, and then we argue for the most, the maximum punishment allowed by law, you know, in that case. But then ultimately it's a judge's decision, and that's the way our system works.
The fact is every jurisdiction, state and federal, every county has about 80 to 90% of their cases, generally close to the 90 range, are resolved by plea bargains. It is the compromises, if you will, that we engage in to make sure the wheels of justice move. The federal government now refers to them as change of pleas, because they know that the expression plea bargains is so politically sensitive or inflammatory. It's the same thing. I don't get to find anyone guilty. I get to charge them with a crime, but this is the way they get found guilty. A jury convicts them, or they plead guilty. So we say, look, here's the evidence. You can go to trial or not. If you plead now, and we don't have to go through the cost of witnesses, trial, all the work we're not doing while we're trying your case, and the uncertainties, witnesses not showing up, stories changing, which happens, then you do get a reduction in what we would get if we successfully took you to trial and won. You cannot be so wrapped up in a particular punishment or a particular case or thing that you become, in essence, you risk adding another unlawful act to an already unlawful act. And that's, you know, the law recognizes that. That's why we have things like the exclusionary rule. If law enforcement or I get evidence against the law, violate the Constitution. Some people say, well, that's technicality. The evidence was kept out because of a technicality. First of all, the United States Constitution can never be a technicality. But also, the reasoning behind it is twofold. One is the state, the government, should not benefit from its own unlawful activity. Because if they do what we've done, one, we've added an incentive for them to break the law, which is a bad policy. The other is we've added another unlawful act to an already unlawful act. Where is the justice there? What have we stood for as a society, as an individual, as a system of government? Unlawfulness. So every day, we pick jurors and we say, look, can you apply the law, whether you agree with it or not? And people, sometimes go, you're asking me to get rid of my morality? And I tell them, no. I want you to have all your morality. But you don't get to apply it here. Because the reason why is if you don't apply our laws, the question becomes, whose laws are you applying? Whose laws are we going to hold this person accountable for? And what opportunity do we have to discuss them, to evaluate the merits of them, to decide whether we're all going to be subject to them? And that's what happens every day when people say, I want you, Paul, to punish this person the way I want them punished. Because they want me to put in their system of laws and not our system of laws. And that can never be anything but an injustice. There's a lot of talk about grow houses in Arcata. And this is how simple it is. And it will never be anything but this. We get a case where there is clear evidence of illegal activity. I don't care whether it's related to marijuana or whatever. Guess what? We're going to prosecute it. No ifs, ands, or buts. That's how simple it is. You think someone has an illegal grow? Don't think it. Make a report. Let them do an investigation. When they're done with their investigation, they will forward it to us. Most law enforcement agencies do call us. We work with them completely to figure out whether we can put a case together. That's how simple it is. You don't just get to say something in our system of government. You have to prove it. I mean, in the court system of government. In politics, you can say all sorts of things. But the court system, you have to prove it with evidence, admissible evidence. So you think something's illegal, you let us know. You let your law enforcement agency know. The responsibility at that point is for them to investigate it. When they have done that investigation, if they believe that it's illegal, they will forward that report. And rest assured, if there is evidence that those people are engaged in illegal activity, I don't care what it is, we will be filing a case.